Good morning, everyone. Thank you for joining us on our webinar regarding recruitment and employment in South Africa. I'm joined this morning by my colleague, Bronwyn Kodisang, who's actually relatively new to the legal department. She joined us in July, and this will be her first webinar that she's joining me on today. But without further ado, let's proceed into the webinar. One thing to remember about South Africa is that it is quite a complex legal environment regarding employment. We have a number of primary pieces of legislation which look after employees and regulate the employment relationship in South Africa. Primarily amongst those are statutes such as the Labour Relations Act, the Basic Conditions of Employment Act, the Employment Equity Act, and a number of other statutes that have an impact on South Africa. What's also important to remember is that South Africa is not just governed by statutes, but it's also takes into account common law. So our law develops as time goes along. So it's also important to have regard to case law, up-to-date case law, and also in respect of employment contracts, because those basically regulate the terms inter partes between the parties to the employment contract. Another important consideration to remember is that notwithstanding the status of the individual who's employed, so whether or not they're a local citizen, a permanent resident, or even a foreign national who's undocumented, our labor laws apply to them. And that's important because we'll deal with that later in the webinar itself. So the first thing to consider when you're hiring an employee in South Africa is whether or not they are eligible to work in South Africa. So the key is whether or not they're eligible to work and reside. And not necessarily being able to reside in South Africa enables you to work in South Africa, and it's important to remember that. So the employment of individuals in South Africa is regulated by the Immigration Act and also the Employment Services Act. Now, the Immigration Act sets out a number of types of visas that are available to employees, foreign national employees who wish to work in South Africa. Primarily, they are the general work visa, intercompany transfer visa, or the critical skills visa. Each of those are available to employees wishing to come into South Africa as foreign nationals and work, and they're valid for a certain amount of time. And the Employment Services Act makes it incumbent upon employers to ensure that the employees who are foreign nationals have the requisite work visa before they commence work in South Africa. And it's always appropriate to make sure that you take advice around visas because it is quite a tricky issue. And a lot of employers fall into the trap of employing foreign nationals in permanent contracts when in fact they should be employed in fixed term contracts. And this creates numerous issues once the visa expires and you wish to dismiss the employee. So you need to be very, very certain about that, because failure to comply with the legislation can lead to both the issuing of fines by the Department of Employment and Labour or imprisonment, and it also constitutes an offence in terms of the Immigration Act, which also carries fines and imprisonment as penalties. Now, it's obviously most of you are aware of what's going on in the news at the moment. There's been a massive crackdown by the Department of Labour and Employment regarding the employment of foreign nationals. At the moment, the industry that is being targeted is the hospitality industry, and it has resulted in roughly about 181 arrests of foreign national employees, together with employers who knowingly hired these foreign nationals. So at the moment, the Labour Department is expanding its investigations regarding illegal labour practices, and that's being expanded into both the construction and retail industries, and I'm sure that it'll expand even further. At the moment, there's about 2,000 labour inspectors that have been appointed to conduct inspections throughout South Africa. And recently, the minister has declared that they shall be increasing that number to 20,000. So it's an increase of 18,000 inspectors. And what you are going to find is that there will be multiple inspections in a year. Some of our clients, particularly those in the retail industry, are inspected up to 3 times a year. And what we are noticing is that they're cracking down on the employment of foreign nationals, B, they're looking at whether or not you comply with the national minimum wage legislation. And more importantly, they are cracking down on what they call illegal employment practices. And those extend both into health and safety and into terms and conditions of employment. So making employees work, for example, unremunerated during overtime periods, not allowing rest periods, excessive work hours, those sort of things are being cracked down on by the Department of Labour. And there's been a number of fines that have been issued around those particular issues and around the failure to pay the national minimum wage. There's been an uptake of about 150% in terms of inspections in Gauteng and the Western Cape province. So it's important just to bear that in mind, that whilst you might not have been inspected recently, the likelihood of that happening is now becoming far greater in these circumstances. Now, another important thing to bear in mind is that the Minister of Labour and Employment has issued two new bills and a draft paper on national labour migration policy. So the bill is on the Employment Services Amendment Bill, and the primary objectives of these pieces of legislation and policy deal with the labour migration governance and management, labour migration to and from South Africa, and the introduction of a foreign national quota system. The draft national labour migration policy is quite interesting because it deals with how best to set up a migration policy that serves national interests. And one of the key areas that their policy seeks to deal with is to address South Africa's shortage in terms of skills, critical skills. And one of the other issues that it wishes to seek to readdress is this growing number of irregular migrant workers in South Africa. All of us are aware that multiple countries provide migrants into South Africa, whether they come from Zimbabwe, Mozambique, Malawi, or even further north, Congo. They end up in South Africa, and a large majority of them are undocumented and look for work as irregular laborers. Now, what the draft policy also seeks to do is to attract and retain critical skills. And interestingly, yesterday the Minister of Home Affairs made an announcement that they are looking at they're re-looking at the work visa system, which they find to be archaic and possibly even colonial. And it is due to the nature of the way that work visas are granted, they are precluding certain critical skills that can come into South Africa, particularly from China and India. And on that basis, they're looking at moving towards a point-based skills system in terms of granting visas. So that attaches to the policy of looking to attract and obtain critical skills. But at the same time, one of the things that the policy seeks to address is imposing quotas to protect opportunities for local workers. And I think that's the key, is that that the government wishes to protect the local workforce, and if there is a foreign national that needs to be employed, it's done in accordance with a quota. Now, this is further discussed in the Employment Services Amendment Bill, which deals with the regulation of employment for foreign nationals in South Africa. It's just a bill that hasn't been passed into legislation yet, but it also introduces an interesting concept called the digital labor platforms. So that's, for example, an easy example, what is a digital labor platform is something like Sweep South, where you log on, you hire a domestic worker or a gardener for the day, and they get then paid through the digital labor platform. So the Employment Services Amendment Bill will seek to regulate that type of an arrangement and impose certain terms and conditions that attach to that. Regarding the employment of foreign nationals, the bill will seek to make sure that before you hire a foreign national, that there is no local South African who can fill that skills vacancy. There also must be a requirement. There's also going to be a requirement then, if you do hire a foreign national, that there's a skills transfer plan which would need to be between the foreign national and certain individuals that are employed to take their place once their employment ends. The minister will also be empowered to provide specific quotas regarding foreign nationals, and the minister will be entitled to draft and present certain regulations regarding the employment of the nationals, foreign nationals. So it looks like this is going to become quite a regulated side of the industry. But I think, given the comments that were released by the Minister of Home Affairs yesterday, it'll be interesting to see if the government decides to adapt its stance around this particular amendment bill, which was released in 2022. So it's already 2 years old, and no action has been taken by government. Another important concept or that needs to be done when hiring an employee is the concept of written particulars of employment. So contrary to popular belief, there's actually no requirement in our law to enter into a employment contract with employees. So what the Basic Conditions of Employment Act speaks about is that you must you must provide the employee with written particulars of employment. Now, those written particulars of employment are required to be in line with the basic conditions that are prescribed in the Basic Conditions of Employment Act, and would need to set out, for example, the hours of work, the leave entitlements, the remuneration terms and deductions, termination and notice periods that are applicable to those particular employees that are hired. As I stated, the Basic Conditions of Employment regulates employment in South Africa and prescribes certain basic terms and conditions of employment that are applicable to all employees in South Africa. And again, just to touch on that, no matter if you hire an undocumented foreign national, the Basic Conditions of Employment Act would be applicable to that individual. And there's a plethora of cases that deal with that, and that a lot of people feel that they can hire foreign nationals because they can treat them inferiorly to local employees and dismiss them at will. That is not the case, and those individuals are entitled to relief in law and may approach, for example, the CCMA to be reinstated and to receive back pay, provided they meet certain requirements in terms of their claim. But basically, those employees are protected by law. Now, having said that, there's no requirement to provide written contracts for employees in South Africa. My advice to you is that you should always enter into employment contracts with employees, and they should be sufficiently detailed, and they should include, for example, provisions relating to data processing, electronic communications, your benefits, confidentiality and intellectual property, and if applicable, restraints of trade. And case law has said that where the Basic Conditions of Employment Act or other acts are silent, the employer may regulate that particular aspect of employment through contract. So it's always important to make sure that the contracts that you enter into with your employees are fit for purpose, and obviously taking into account the position that the employee is employed in. So for example, hiring somebody who would conduct menial tasks, their employment contract would be a lot simpler, while someone who's in a management position or an executive position, you would expect to find that they have a much more complicated employment contract that deals with issues that are pertinent to their job, such as, for example, electronic communications, access to electronic devices, and so forth, particularly in this age where we have so many devices that we have, work emails on, that people are provided with work mobile phones. Those things need to be dealt with in terms of a properly executed employment contract. All employers are also required to adhere to the national minimum wage, and this applies to all employees, as I've stated, except to certain government agencies. I'm assuming that there's no government agencies on this webinar, so I won't detail who they are. But basically, what the National Minimum Wage Act says is that employers may not pay remuneration to employees which is less than the national minimum wage. So as at the 1st of March, the current national minimum wage is 27 Rand and 58 cents per hour. So that amounts to about 4,781 Rand and 27 cents per month if the employee works 8 hours a day, 5 days a week. So it's not a substantial sum by any means, and it is quite important to note that this does not constitute a living wage. So there's a movement in South Africa to move towards a minimum wage, which is equivalent to a living wage, but we're still quite far away from that. So failure to comply with the national minimum wage, there's a number of routes, but primarily what will happen is that the Department of Labour will inspect you, and from there they can proceed with providing you with compliance notices, so requiring you to back pay whatever you short paid in terms of the national minimum wage. Alternatively, they can provide compliance orders and fines. The other alternative route is for the employee in question to approach the CCMA and to get the CCMA, the Basic Conditions of Employment Act has recently been amended to provide relief in terms of the national minimum wage, which allows employees to approach the CCMA for an order compelling the employer to back pay and comply with the national minimum wage requirements. In the past, matters relating to remuneration could not be pursued in the CCMA, and you could only pursue matters relating to unfair labor practices or dismissal. Now you can bring specific, provided you earn under a certain threshold, you can bring specific, apply for specific relief in the CCMA regarding the national minimum wage. As I stated previously, the Department of Employment and Labour is on a massive drive and crackdown regarding non-compliance with the national minimum wage, and it is seen in quite serious light. And I think the last news report that I saw, something like to the tune of 3 million Rand had been recovered for employees in the last couple of weeks just from this crackdown. So it tells me that there's a pervasive issue in employers that fail to pay their employees according to the national minimum wage. The employers should be aware of the Protection of Personal Information Act, which is what we call POPIA. This regulates the processing, retention, and general management of personal information for individuals. And it's very important to employers, the employee and the employer relationship. If you think about the very nature of the relationship, the employers will be processing not only what's determined as personal information, but also what is determined as what's defined as special personal information. And on that basis, POPIA places a number of obligations on employers to establish mechanisms that uphold the privacy and protection of employee-related information. Chapter 3 of POPIA also provides for specific conditions that relate to the lawful processing of personal information. And I suppose the key to the processing of personal information, if you had to sum it up, is that there's required to be consent from employees to allow for the processing of personal information. And that's why I mentioned that it is vitally important in the employment contract to provide for this. So other things that employers would need to do regarding the processing of personal information is that they would need to inform the employees of what specific information is being collected, as well as why that specific information is being collected and processed. So it's very important that employees are aware of what is collected and what is processed. Now, it's important to note that that contravention of POPIA exposes employers to significant risks. There are fines, significant fines in POPIA, and it also creates what's called statutory liability as well. So it's very important that employers are aware of this, and they should not treat POPIA lightly. The regulator is in the process of cracking down on data breaches, on failure to comply with POPIA. And what will happen, similar to what happened with the National Credit Regulator, is as the as the regulator itself gets more teeth and is able to fill its coffers with fines, there will be a much wider crackdown on employers and other individuals who fail to comply with POPIA. So it is always better to rather get your house in order now than wait until the regulator is knocking at your door. Another important piece of legislation just to bear in mind as it relates to the employer-employment relationship is the Electronic Communications and Transactions Act. So what that does is it prescribes that no person, and that would include an employer, may without authority or permission intentionally access or intercept any electronic data or any communications. So what that does is it means that as an employer that you don't have an absolute entitlement to intercept and read your employees' mails, even if they are on your system and on your server. So that is why it is very important to ensure that when your employment contracts are drafted, that they include suitable provisions that deal with the Electronic Communications and Transactions Act, which enable you as the employer to dictate how electronic communications are processed and intercepted utilizing your own system, computer systems. This will assist, for example, where there's issues of fraud, corruption in the workplace, and those need to be investigated. So it's important to ensure that you have similar types of provisions in your employment contracts to deal with those particular aspects. Employment equity is becoming more and more of an issue in South Africa, and it's not an issue from a bad sense. It's an issue that it is becoming more and more important. What the Employment Equity Act does is it seeks to readdress discrimination in the workplace and to implement what's called affirmative action in the workplace as well. So what the Employment Equity Act does is it prescribes who are designated employers, and the test for that is anyone who employs 50 or more employees. And there's other criteria as well, but the main test is whether or not you employ 50 or more employees. If you're a designated employer, you're required to comply with the affirmative action provisions in the Employment Equity Act, and that prescribes that you have certain reporting obligations as well. So that means you have to file what's called an employment equity report, and you have to prepare a 5-year employment equity plan. The process of attending to that and setting up the background that gets you to that point is quite a process. It typically involves consulting with the employees, with sufficient representatives of the employees from all levels of the employer, of the workforce, and that must include both designated and non-designated employees. Once you've consulted, you would then prepare your employment equity report and your employment equity plan based on the recommendations of the employees that you've consulted with. Typically, those employees are housed in what's called an employment equity committee, and they provide advice around what appropriate affirmative action measures should be implemented by the employer, together with if there are any barriers to entry and the like, and how we're going to improve to make sure that the workforce more importantly reflects the economically active population in South Africa and in regards to certain areas. So it's quite an important piece of legislation to be aware of. Failure to comply with it can result in fines as well and other penalties. Now, it's important to note that whilst related, employment equity does not equal Black economic empowerment. There are separate concepts in our law. Black economic empowerment will utilize employment equity data, so there's a requirement depending on how you're rated on the BE level, that you would need to utilize your employment equity data to assist you in preparing your Black economic empowerment certification. But they do not equal each other, and one is not the substitute for the other. So because you've complied with the employment equity legislation, does not entitle you to a Black economic empowerment certificate, and similarly, because you have a Black Economic Empowerment certificate does not entitle you to be rated as compliant with employment equity. So those are two separate concepts. So thank you for joining us, and it's important just to remember that South African legislation, it covers a myriad of employee rights and entitlements. And what is also important to understand is that there's an emphasis placed by our legislation, by the Department of Labour and Employment, and our courts on fair labour practices, on economic development, on safety in the workplace, and social development. They are very, very important aspects of our law at the moment. And I cannot stress it enough that they should be given the critical that employers should ensure that they comply with them, and particularly given the crackdown by the Department of Employment and Labour at the moment. If you have any questions, we're not going to take questions on the webinar, but if you have any questions, please feel free to email them to myself or Bronwyn, and we will consider them and respond to them as soon as possible.